Welcome to those joining us right now. We're just going to get started in a few moments, just letting people get signed in. Again, welcome to everyone joining us right now. We're going to get started in just a few moments. We're just letting people get signed in. Again, just anyone joining us right now, we're just letting people get signed in. We'll get started very shortly. Okay, so it looks like most people have signed in now, so that's great to see. I'm going to just go ahead and share my screen so we can get the slides up as well. Perfect. Well, thank you everyone for joining me today and for this session on renting out your condo unit. My name is Hunter Boucher. I'm Vice President of Operations here at LandlordBC, and I'm really excited to be able to share this information with all of you today. Throughout today's webinar, if you have any questions, go ahead and put them in the Q&A box. I'll get to them at the end, but as you think of them, go ahead and put them in so you don't kind of get to the end and realize, oh, I can't remember what I was going to ask. So just go ahead and put them in right away. And like I said, I won't be ignoring them. I'll get to them at the end of our presentation today. Also, if you stick through to the end, there's a couple of contests that we like to mention in a giveaway, as well as a coupon code for membership. So be sure to stay through to the end. Okay, looks like most people are in. So we'll go ahead and start. So today we are going to be talking about the top 3 tips, or really the top 3 things that landlords of condo units should be aware before renting out. A bit of information about who we are. LandlordBC is the industry leader for the residential rental housing industry in British Columbia. So we are a province-wide association. It is our mission to support you as rental housing providers and your rental housing business. And this is really it's whether you have 1 unit, hundreds, thousands of units, it doesn't matter. If you have 1 unit, you are running a rental housing business. If you have thousands of units, you're running a larger rental housing business, but it's the same business. And a lot of the same laws and pieces of legislation, rules and such apply. We pride ourselves on the professionalization of the rental housing industry through education and support, and of course, most importantly, through our government advocacy that we take so seriously. So, here. So, and when it comes to our memberships, or our members, they range from owners to property managers, with purpose-built rental properties, with single units, investment suites, with condos, and so really what we're here to do is make your lives easier as rental housing providers. And by making your lives easier, really making everyone's lives easier within the rental housing ecosystem. So landlords and tenants, we're really here to provide as much information and support in that way. So today, our top 3 tips for landlords, what we're going to be talking about is establishing a successful tenancy, going over Form K, notice to tenants of their responsibilities. We're going to talk about strata council or management and your tenant and how that can relate. Like I said, if you have any questions throughout, put them in the Q&A and I'll happily get to them at the end of the session. So when it comes to establishing a successful tenancy, it really comes down to doing everything you can about setting yourself up for success. And really the best way to set yourself up for success in really any business relationship, because that's what we're talking about. A residential tenancy is a form of business relationship. You're running a business and your client is a tenant. They are renting from you. And it's really important to make sure that you strike a balance between documentation and communication. Both are equally important, and for different reasons. We want to make sure that things are documented, to make sure that things are clear and understood, and we have something to go back to when there's questions throughout a tenancy. But communication is important as well, because as much as we can document anything we want, people don't always read everything. People don't always remember everything. So making sure that we're communicating throughout the process, throughout a tenancy and before a tenancy. So that's where we're going to start. We're going to take a look at before a tenancy even begins. Really, establishing a successful tenancy starts with a tenant selection process. It's a chance for you to get to know someone in really a rather short period of time. You've likely had minimal contact. You placed an advertisement online. They've responded, and in a fairly short period of time, you have to decide whether or not they're a good fit for your rental unit, and that's a very sometimes scary decision to make. And because we've certainly heard horror stories occasionally in the media about problematic nightmare tenants. The reality is most tenancies are quite successful. And they're successful because they're built on a good foundation of communication and of course documentation. But they also start with that strong tenant selection process. So when it comes to tenant selection, the first thing that we need to do is make sure that you have a process that you can count on, that it has worked for you in the past, and that you're continuously considering, is there improvements that you can make to that process? And that process can look like a lot of different things for different landlords, but the key really to pretty much all of those processes is going to be using an application for tenancy form. You really want to make sure that you have a trusted application for tenancy form, one that gets you the most amount of useful information without invading unnecessarily the applicant's privacy. So it's really important to make sure that the application form that you're using is from a trusted source. Now, we at LandlordBC provide an application form to our members in the members only section of our website. If you go online, you can search application forms. That being said, if you do a Google search to look up application forms, you have to be really careful that the one you're going to find and use is in fact compliant with provincial legislation. Because of course there's applications from all over the place, not all of them compliant within British Columbia, within the laws of the Residential Tenancy Act, the Personal Information Protection Act, and of course the Human Rights Code, which are the 3 kind of primary things that apply in residential tenancies, specifically during the tenant selection process. Part of that process should also be talking with the tenant. You want to make sure that you are communicating with your tenant or your applicant and getting to know them as much as you can, asking them questions about, why are they leaving the place that they're currently leaving? What are they looking for in an apartment or in a place to live? Getting those pieces of information, really early in the process, perhaps even throughout the process, is an important way to get to know them, but also to kind of start opening up those lines of communication that will be used throughout the tenancy. An important part of this communication is, listening to them and, making sure that, what they're answering meshes with what you're going to be offering. So if they describe, what they're looking for in a place to live, and that your place isn't going to meet that, they're saying, we want a place that has lots of storage. And that your place has very minimal storage, for example. Well, it's probably best to say, well, there is some storage in the unit, but it is somewhat limited, so that there isn't a surprise down the road. And to make sure that while you're trying to sell the unit, you also want to make sure that it's a sustainable and long-lasting tenancy. Part of your tenant selection process should also be, of course, checking verifiable sources. This might mean doing things like running a credit check, for example. If they've provided you with references, going online to try to verify those references. If they said the previous landlord was a property manager, for example, going online, finding the property management firm and contacting them through that method to verify that they're giving you a reputable and accurate reference. The last, but probably really the most important part of a successful tenancy selection process is being comfortable with saying no. The reality is you likely have one tenant, one unit available, and with one unit available, you're going to have more applicants than just one. You're going to probably have 10, 20, 30, which means the reality is most of the people that you'll be talking to, you're going to be declining. So you need to get really comfortable with saying no. And that can be a difficult thing for anyone, landlords, it doesn't matter who you are. Saying no is sometimes quite difficult for most people. So it's something you have to be really comfortable with, that it's not necessarily a personal thing. The reality is you can only select one tenant or one group of tenants. So you're not, it's not a personal thing, it's just sheer numbers. Part of establishing a successful tenancy beyond the tenant selection process is, of course, making sure that you have a thorough tenancy agreement. You want to make sure that you want to communicate throughout the selection process and through to signing the agreement, and of course throughout the entire tenancy, to make sure that you're setting up any important expectations and rules you might have in the tenancy. Things like no pets, no smoking. But don't rely on, say, your advertisement or those conversations for enforcement. You need to make sure those rules are in place in your tenancy agreement. So any rule that you want to rely on throughout the tenancy needs to be in the tenancy agreement. A good way of ensuring that you'll have the clauses that you want in your tenancy agreement is using a trusted form. In BC, there's really two primary trusted forms. There is the one provided by the residential tenancy branch, and there's one that we provide to our members. The one provided by the residential tenancy branch is, of course, compliant with the provincial legislation, as is ours, but it is rather simple. It doesn't cover a lot of things that can come up through a tenancy. And that's important to be aware of, that while the government agreement is a good foundation for a tenancy, it's a good beginning part for a tenancy, you want to make sure that if there's additional things, what needs to be added to the agreement. So that's where searching out another more comprehensive agreement, such as the LandlordBC agreement, is a good idea. If you're going to add your own clauses, you need to make sure that you do some research on how to add clauses to the agreement. three kind of primary things is that they must comply with the Residential Tenancy Act, or maybe another way is they can't go against things that are in the Residential Tenancy Act. For example, in the Residential Tenancy Act, it talks about how there's rules regarding timing and amounts of rent increases. You can't write a clause in your agreement that goes against those rules about timing or amounts of rent increases, because the Residential Tenancy Act is already clear on that part. Additionally, your clauses that you might want to add need to be clearly worded. They need to be worded in a way that is enforceable, but also clear and understandable by the average person. So if you go to a friend of yours who's a lawyer, for example, and you get them to write the most ironclad, best contract they've ever written, but it can only be really understood by other lawyers, it's not necessarily going to be enforceable, because it needs to be something that is understood and clear to the average person, to the person who's going to be signing the agreement. And lastly, the terms of your agreement must be not considered unconscionable. And that means something that is grossly unfair or oppressive to the other party, namely the tenant in this case. So again, it comes down to using a trusted form. And really, if you use a trusted form, the added clauses part is really already covered for you. When it comes to filling out the form at the end, you need to make sure that you do fill it out completely, and that it is in fact signed by both parties, by you and of course by the tenant or tenants if there are multiple of them. We're going to take just a quick moment before we continue on, just to do a quick poll of the people who are here in today's session. We'd like to just get a bit of information about the demographics of the people who are present. So I'm just going to launch a poll through Zoom and go ahead and answer the questions. And it is anonymous, the information that you are sharing. This is just to give us a sense of who's attending, the types of services that you might need. We're going to, after this, also send out a survey with a bit more information as well. But this just gives us a bit of an idea of where we're at right now. I see people are sending in their answers. Appreciate that. Fantastic. So I'm just going to end the poll now. Thank you so much for participating. That the information really does help us when it comes to webinars like this, future webinars like this, and the services that we provide. Fantastic. Thank you. So we are just going to close that and go back to our slides. So we've talked about setting up a successful tenancy and documentation. And like I said, before we move on to Form K, the whole point of that is to ensure that you have clearly documented what you want out of this tenancy, but also you want to make sure that you communicate that with your tenant. So when we go back to the tenancy agreement, we talk about using a trusted form. We talk about things that might be specific to your property. When you go through and fill out that tenancy agreement, you should also really be talking with your tenant while you're doing it and going through the terms of that agreement, making sure that they understand it, making sure that they are aware of perhaps maybe the severity for the severity of what can happen if they're not compliant with the term of the agreement. So, for example, say a no smoking clause, the likely what will end up happening is it might end their tenancy if they continue to smoke in the unit after you've given them a warning. So, it's a chance to make sure that everyone's on the same page and understands what is expected throughout this tenancy. And like I said, you want to do this while signing the agreement, but you also really want to do it even before that, when you're having that conversation with the applicant before you've actually agreed to rent to them. Having a conversation about some of the expectations that you have is really important to ensure that they're not getting into something that perhaps they're not willing to get into, or that they will be surprised of later on. Now, most of the clauses that we've talked about, things like pets and smoking, are a bit more common clauses. I think people generally seem to expect those these days, but nonetheless, you want to make sure that it's really clear. So, moving on to Form K. Now, this is something that's really specific to renting out your unit in a strata, in a condo unit. So it's Form K, Notice of Tenant's Responsibilities. This is a form that documents that a tenant is responsible for adhering to the strata bylaws and that they have been provided a copy of those bylaws. The form really covers three integral or important vital parts. It's kind of three terms or clauses to this, along with gathering information and documenting who the tenant is and such. So the first part is that under the Strata Property Act, a tenant in a strata corporation must comply with the bylaws and rules of the strata corporation that are in force from time to time. Current bylaws and that may change from time to time. Current bylaws and rules must be attached to the form as well. So the current bylaws may be changed by the strata corporation, and if they are changed, the tenant must comply with the changed bylaws and rules. And if the tenant or occupant of the strata lot or a person visiting the tenant or admitted by the tenant for any reason contravenes a bylaw or a rule, the tenant is responsible and may be subject to penalties, including fines, denial of access to recreational facilities, and if the strata corporation incurs costs for remediating a contravention, payment of those costs. So it goes in addition, essentially, to the tenancy agreement, which is important because you don't have to put all of the rules of your strata in the tenancy agreement. You simply have a Form K along with attached bylaws. So you want to make sure that you check with your strata council or management for this form. They likely, if you have a strata management, if your strata corporation has a management company in place, then you want to check with them. They likely have their own version of the form, likely just branded. The contents are pretty much the same. I haven't really seen any deviation when it comes to the actual form itself. You generally want to sign this when signing the tenancy agreement, and you want to provide a copy to council or management. And again, this is about making sure that you communicate with your strata corporation's council or management before renting out, that you make sure you get all this information to make sure that that is really clear. So the strata, so what we want to look at here is, so moving on to the next topic here is how the strata council or management, the strata corporation can be different from, and how it can affect your tenancy in ways that are perhaps a bit different than, say, someone who's renting a purpose-built rental. So if you look at the average tenancy in BC, the average tenancy in BC is a purpose-built apartment building where all their neighbors are going to be other tenants, and so moving into a building that is a strata building, it might be their first experience living in a strata. And for anyone who's not lived in a strata and then has recently moved into one, you know that there are some certain differences between living in a condo and living in an apartment building. Um, the key difference is that the neighbors are likely to be owners in the building. There might be other tenants of other owners, for example, or if you just so happen to own multiple units side by side, then perhaps they're your tenants. But generally speaking, it's quite likely that the other neighbors are going to be owners or potentially tenants of other owners. And that's important to note because the way you deal with issues that can arise between neighbors is really different than in condos and stratas, compared to, say, an apartment building, where you as a landlord in an apartment building generally are the landlord of all of the tenants in the building, and thus responsible for things like the quiet enjoyment of all the tenants in the building, and have authority over those tenancies. And whereas in a condo situation, generally you don't have authority over issues that arise between neighbors per se. So if your tenant is causing issues, you might have to take action, certainly, and that'll likely look fairly similar to how you deal with things through the Residential Tenancy Act. But if it's the neighbor that's causing the issue for your tenant, you're not going to be able to go to that neighbor and issue them a caution notice like you would, say, a tenant in an apartment building. You're going to have to deal with going and communicating with either your management or your strata corporation's council, if there's some type of complaint process through that, utilizing that. The other part to be aware is that you essentially become an intermediary between communications between your tenant and council or management. So it's important to note that occasionally there are going to be pieces of communication that will come from your strata management or your strata corporation's council that might affect the tenant in some way. Now, oftentimes, communications like that will get served to potentially your tenant if it's, say, they posted it on the door, for example, or posted in common areas. But if it's communication that came directly to you, say through your email or other means, you want to make sure that you're passing that information on. And that is especially important if it's going to, have an impact on your tenant in some way. Things like, say, repairs being done in the building, or if for some reason there is entry needed into the unit. And that's where it becomes really tricky and really important that you're on top of those types of communications, because you want to make sure that your tenant is given proper and compliant notice to enter for entry before whoever it is that needs to enters into the property. So if it's a tradesperson, for example, so you want to make sure that if you receive communication that impact your tenant in some way from management or from the Strata Corporations Council, that it then gets passed on. It's also important to note, though very unlikely, that your strata council could end tenancy without you being involved. Now, I say this, the reality is it's not really a likelihood for this to occur. But it is something that the Residential Tenancy Act does recognize. The residential tenancy branch, the governing body that kind of covers residential tenancies in general, is working at creating a forum for strata councils to be able to serve tenants, to be able to end tenancy. But it needs to be a pretty significant situation, and it also generally needs to be a situation where it's been ongoing and you as a landlord haven't really been involved. I wouldn't generally be worried about the fact that strata council can end the tenancy without you being involved, unless you plan on really just not being involved in any way with that tenancy at all once it's set up. The other important difference between renting out a unit in, say, a purpose-built apartment building versus a condo in a strata complex is that infractions may come with fines. So, in an apartment building, if the tenant continuously causes issues for other tenants, there's generally no financial impact from that, other than potentially a loss of other good tenants if they decide, if it's not dealt with appropriately. But within a strata, within a condo, there's the possibility of financial implications for you, because there is the possibility of fines, and those fines can be not necessarily insignificant and potentially frequent if you don't take appropriate action. Now, of course, with those fines, you're able to go and to your tenant and ask them to cover those fines that they incurred, and they are responsible for that under the Residential Tenancy Act, and again also through signing Form K. But collections can sometimes be difficult, and you need to just be really aware, especially when it comes to the tenant selection process. You want to make sure that you are putting someone into the unit that isn't going to cause issues for other people and potentially cause issues for you that could have financial repercussions. So much like with your tenant, communication with other owners, council management is really important to keep on top of issues. So you want to make sure that when you're, say, at a council meeting, that you talk with other people about making sure that everything's good with the tenants, that you have those open lines of communication with your management or council to make sure that as soon as an issue arises, so that you can then deal with it, which of course is going to help you in the long term when it comes to avoiding things like potential fines and penalties. So I see that quite a few questions have come up, so this is good. So some questions that have come up. First question that has come up, and like I said, go ahead and put as many questions as you want into the Q&A, and we'll try to get through as many of those as we can. And after we do a bit of Q&A, we have a bit more information about membership and a discount on that. So first question that's come in is there a government-controlled limit to the amount of security deposit that you can ask for? That's a really good question. And you want to, when it comes to security deposits, it is up to half a month's rent for security deposit that you can request. Additionally, if you allow a pet to be kept in the unit, which obviously you want to check with your bylaws about that as well, you want to make sure that that you are allowed to allow that within your tenancy. That can cause big issues, but if you do allow it, and the bylaws do allow it, you can take another deposit of up to half a month's rent. So between the two, you would have a full month's rent for deposits. So again, short answer, security deposits are half a month's rent. And just a clarification, the Form K doesn't require the bylaws to be rules to be attached, but it does state that they have been provided to the tenant. So you want to make sure that that if you're expecting the tenant to abide by the bylaws, that you are in fact that you are in fact providing them with access to that. You also want to make sure with your management company that the form that you're using for Form K is in fact the prescribed form. We see this within residential tenancies all the time, that forms can occasionally get misused, and with forms that or not so much misused, but altered. So you want to make sure that the form that you're using is going to be compliant. I have a question about Form K being required for short-term rental or license. I'm not aware of that myself. We deal specifically with residential tenancies that fall under the Residential Tenancy Act, which we generally deem to be long-term tenancies. So I don't have any information about that. You'd want to check with your management or council on that. Perfect. A couple more questions that have come in. Actually, we have someone in the webinar today that is also an expert in this as well. And short-term tenancies are not tenancies under that. So Form K doesn't apply in those situations. Okay, so I have a question here about insurance requirements for tenants. And actually we have two questions that are pretty much the same question. Can you address insurance requirements for tenants, and can you request proof of tenant insurance as a condition of tenancy? So under the Standard Residential Tenancy Act itself, it does not talk about tenants needing insurance or not. So we look into the Residential Tenancy Act or under the residential tenancy agreement provided by the residential tenancy branch. Neither of them talk about that. So if you are going to have, if you want to have something in place that requires a tenant to have insurance, it would need to be added to your agreement. We actually have that in our agreement, in the LandlordBC agreement. So if you're using the LandlordBC agreement, the LandlordBC agreement does provide a situation where, or does provide a clause that states that a tenant insurance is provided, and that you as a landlord may request proof of that insurance from time to time throughout the tenancy. It's a difficult thing when it comes to enforcement, but most certainly it can be in the agreement. You need to be careful about the wording, again, which is why we work with lawyers to make sure we make sure that our agreement is compliant and enforceable. So the next question is around pet deposits, and specifically is, are you allowed to take a pet deposit for each pet? And the answer is no. You have one pet deposit for the tenancy, and that one pet deposit is a maximum of half a month's rent. So if you allow 2 pets, it's still just that half month's rent for all of the pets total, not one per. Just one moment here, just getting to the next questions. Just a comment to specifically around the about the communication side of things. I want to make sure that it is clear that you generally shouldn't have to be an intermediary between your strata council or management. It requires the strata to communicate with your tenant. But with that being said, you need to make sure to ensure a successful tenancy that those communications are in fact happening. So it often does end up that you are in fact the intermediary. And that's one of those things where it comes down to making sure that you have good communication with your strata council or management as well. I did mention earlier that the Residential Tenancy Act talks about ending a tenancy through the that a strata council can end a tenancy. And that is something that's actually specifically in this Strata Property Act and in an RTB policy guideline. The Act itself doesn't have that in it. The Residential Tenancy Act doesn't have it in it, but it is in the policy guidelines, so it is allowed, and they are working at creating a form for it at the Residential Tenancy branch, which will be something that'll be very helpful. Okay, so the next question here is around using email as a method of service. So within a residential tenancy, email is an approved method of service, but you need to have something in place, some type of documentation that the tenant has provided that email address as a method of service. So it's something that you need to make sure is really clear in either the tenancy agreement, we put that in our tenancy agreement, or that you use a government form. And there is a government form in this case that can be really helpful to document that email is going to be used as a method of service in this tenancy. It's important to note that with email as a method of service, it is something that is it's consent based. So it's not just a given that email will be a method of service. The tenant has to consent to it or has the option to consent to it. And they can remove that consent at any point during the tenancy or even after if there's reasons for communications after. So it is something that you need to make sure you have good documentation on if you're going to be using email as a method of service. Also important to note that when it comes to documentation or when it comes to methods of service, there are other methods of service. You want to make sure that you as a landlord are always following the methods of service that are permitted under the Residential Tenancy Act. Those include things like giving it directly to the tenant, posting it on the tenant's door. And it's something to be clear is that when it comes to posting it on the tenant's door, my understanding this is not something that is allowed from the Strata Property Act. Specifically, so council or management cannot use that method. Now, you as a landlord can use that method because you are acting then under the Residential Tenancy Act, and that is a different piece of legislation altogether. So, and that's where those differences between those legislations become really important to be aware of. Here, just going to the next question. Okay, so the question here, actually just going back to the strata bylaws, specifically if a tenant were to breach them, and is that an immediate end of tenancy or is there a form for that? So someone's asking about, how do we end a tenancy in a situation where there's a breach of a rule, whether it's and this is really the same, whether it's a bylaw in the strata, or if it's a term in the tenancy agreement or something within the Residential Tenancy Act itself. And the answer is, generally speaking, if there's a breach of a bylaw or a rule in the tenancy agreement or a rule in the act, in most cases, you're going to be providing a caution to the tenant, some type of warning to the tenant, informing them that there has been this infraction and they need to ensure that it doesn't happen again. And then if it were to happen again, in most cases, the next step would be a notice to tenancy. Now, this is going to be very dependent on a number of factors. One, the severity of the infraction is obviously really important to consider. In some very more extreme infractions, you are going to go straight directly to a notice to end tenancy. And that notice to end tenancy, whether there's a caution notice before or we're going straight to it, is generally going to be a 1-month notice to end tenancy. It is a form that is provided by the residential tenancy branch. You need to use the government form, which is something that's really important to be aware of, is that you are bound to use those government forms when they're prescribed forms. So some forms are prescribed, some forms are provided by the RTB, but you can have your own. An example is where you can have your own version of the form is a tenancy agreement, for example. There's rules about how to make your own tenancy agreement. We follow those rules for our agreement, of course. But there's also some forms where you must be sure that you are using the prescribed form. And an example would be any notice to end tenancy through the residential tenancy branch, along with things like, say, the Form K, a form that we mentioned earlier as well. You need to make sure you're using the prescribed form in those cases. We have a question here that's come in around ending tenancy, specifically around the strata council ending tenancy or evicting. And like I said before, this is something that is not a common thing. I doubt that anyone on this webinar is ever going to have a situation where their strata council is going to be going through the process of evicting their tenant. And essentially, because it needs to be something that is continuing, it has to be something that just continues to happen, and there generally needs to be, it needs to impact other tenants as well. So there has to be something that's a reasonable rule, and that the infraction, the breach of that rule is seriously interfering with the use or enjoyment of the strata lot. And again, generally speaking, in those sorts of situations, you're dealing with that well before it gets to council saying we're going to evict for it. Hopefully that's the case, is that you're dealing with it well before it gets to that point. So you don't really want to leave those things out of your hand. Question here is around selling a strata unit. In situations where you sell a strata unit and the buyer wants to use the property for their own use, who ends the tenancy, or how is it ended? And that's a really good question. When it comes to purchasing or selling any type of home, if it is rented out and the new owner wants to live in the unit, and it's the new owner or their close family member, and close family member could be their parent or their child, and specifically it is narrowly defined, so it can't be cousins, it can't be aunts, uncles. It is a parent or child of the landlord or the landlord's spouse. If they are going to be using it and living there for at least 6 months, ideally longer, using it as their home, residing in it, you as the seller or the seller can issue a 2-month notice to end tenancy. And to do that, the purchaser needs to make a request in writing. There is a form for that, and your real estate agents should provide you with that information in those forms. Make sure you're using the up-to-date and most accurate one at that time, and then you serve in turn to your tenant the notice to end tenancy. This is only, again, used in situations where they are going to, in fact, use it to reside in it, to occupy it, or it's a close family member who's occupying it. The tenant does get 1-month compensation with this. Additionally, it can't end the tenancy earlier than a fixed term tenancy might if there's one in place already. So if you have a lease or a fixed term tenancy, say for a year, it can't, and you can't use the 2-month notice to end it earlier than that. And again, the tenant does get 1 month compensation with that. When it comes to the payment of that 1 month compensation, that's something that should be worked out in your agreement to sell. So if it's something that you want the purchaser to cover, for example, then make sure that's in there. If it's something that you as a seller is going to be covering, make sure that's in there. When it comes to selling a tenanted property, there's a lot that you want to make sure is anticipated in advance. So you may want to talk to a lawyer when it comes to deal with that. Okay, so we just have one more question that I'm going to get to before we get to just our last couple slides. So thank you again for everyone that has sent in questions. Really appreciate it. So last question here it goes back to selling a property. It's just actually just kind of a further question. So what happens to the security deposit when a property is sold? Does it get repaid or does it get transferred to the owner? When you purchase a tenanted property, so we'll look at it from the other way. If you were to purchase a tenanted property, a condo that has a tenant in it, and you're not planning to move in, you essentially are purchasing the business arrangement, the business that's in place as well. So you inherit everything that goes with it, including the tenancy agreement and the security deposit. So from a seller standpoint, you don't return the deposit to the tenant unless the tenancy itself is actually ending, which selling it doesn't necessarily mean it's ending. If the new owner is going to be keeping those tenants on and using it as a revenue property, you would simply transfer it to the new owner. Additionally, when it comes to that, if the property is being sold and the new owner does want to use the unit for their own use, they're going to be residing in it, occupying it, either themselves or their close family member, they will have to state that's what they're going to use the property for to the current owner. So they provide, basically the purchaser, the buyer provides that notice to the seller. We do want to just extend a special offer to people who have attended today's webinar. If you're becoming a new member before March 30th, you can receive $50 off your first year of enrollment. Simply visit www.landlordbc.ca/memberships to register and use the code Condo. This is valid until March 30th, 2023, and open to new members only. Additionally, you want to make sure that if you sign up by then, you'll also be entered into our giveaway. We have anyone who joins before April 30th is entered into entered to win a chance or a chance to win one of 36 swag boxes filled with some of our favorite items. I know I have a few of them, including a Yeti mug. So the winners will be selected by a random draw on May 17th and be contacted via email or telephone. All you need to do is just sign up as a member. So you can get more information about that at landlordbc.ca, branded swag box giveaway. We're going to send the links as well to this, as well as the code for becoming a member in a follow-up email that'll go out tomorrow. Some of the prizes include things like you get a tumbler, steak knife set, wireless phone charger, laptop LED, and FortisBC has something kind of fun. It's carbon capture soap. It's soap made from a carbon capture process, which is kind of really, really great. I've seen it in the past and it's great. Again, a big thank you to the people who have made that giveaway possible. And after we finish today's session, there's going to be a survey that'll go out. It'll take approximately about 5 minutes. Really appreciate you providing your feedback on this. There's some information around kind of who you are, so we get an idea about the people who are participating in this webinar, as well as feedback about the webinar itself. So again, really appreciate you participating in that. Thank you again to everyone who has attended today, and for your thoughtful questions and for your attention. Thank you and have a good day.